Good morning, everyone. A very warm welcome from a snowy Suffolk to our very first in our Birketts shipping series, going through various shipping topics on time charters, voyage charters, and then cargo claims. It's really exciting to be doing this, so I really hope you enjoy this and find it really useful. So perhaps I can first of all tell you a little bit about Birketts for those who don't know. We're over 700 staff across East Anglia in 5 offices now. We opened an office in London, a small office merging with a boutique insurance specialist team. And we have those 5 offices in Cambridge, Chelmsford, Ipswich and Norwich. We're a full service firm doing all the things you might expect of an English law firm, plus some things you might not immediately think, some pretty specialist areas, of which our shipping and logistics team is one of them. And here we all are. Tried to get the best photos we could. This is the shipping team. This team has grown probably over the last 15 or so years, and a group of us who enjoy working outside London in the countryside, but still doing the sort of work you would expect of any shipping team in the UK. My name is Davey. I'm a partner in the team. I've been doing shipping law for about 23 years. I started my career 6 years at Inson&Co before making the move out to Birketts, and haven't really looked back from there. Sarah, my colleague Sarah, has 12 years experience doing shipping. She trained with Birketts and with us, we do all the sort of things you would expect of shipping lawyers in the UK, and we're always happy to help. So if I can introduce you to the series, as I mentioned at the beginning, we have these 8 sessions on time charter topics, followed by a further series on voyage charters, and then another series on handling cargo claims. They're intended to be an introduction for junior claims handlers, junior lawyers, and a refresher for those who are more experienced. I think it's really helpful to be able to give something back and to go through some topics without spending time going on some niche point on the Supreme Court, which we're always happy to do as well. But the idea of this is to set the scene and give you that basic knowledge of what we're all talking about. This session itself is an introduction. It's an introduction to the course. It's intended to put time charters into context and to give you an idea of the sort of things that we will be talking about through the series. Now, it is a course based on English law, and therefore we thought we'd start with a short intro for those who come from different legal systems and continental legal systems on what it is exactly we're talking about and how do we know what English law is. So perhaps Sarah, you can run through that for us.
Thank you, Alex. There we are. Introduction to Time Charters and English Law is the title of today's webinar. So in this course, as Alex has said, we are going to aim to give you an understanding of what English law says about a number of time charter topics. But before we get into those topics, we thought to consider how we know what English law says, whether it's written down, and if so, where. And by way of an example, when we come on to talk about safe ports later in this series, we'll talk about a case called the Eastern City, which was decided by the Court of Appeal in, I think it was the 1950s. It's important to understand why we are telling you about what the judges said in that case and why what they said is now the law. So as I've put on the slide, there are 3 main sources of English law. There's legislation, so that's acts of parliament. There's case law, which is also referred to as common law, and now to a very limited extent, EU law. The first of these, legislation, is, I hope, self-explanatory. Now, English law is a common law system. This means that decisions by judges are binding legal precedent. Their judgments are the law. This contrasts to a civil law system, which I think a number of you will be more familiar with, in which the law is codified and decisions by judges are persuasive rather than binding. A distinctive feature of the common law system, so the English common law system, is that the law develops through judicial decisions, so that's the decisions made by judges in court cases, instead of through legislation or other texts. In fact, much of English law is not strictly defined. Even where legislation has been passed, this only sets out general principles, and the particular boundaries and definitions of the legislation are provided by case law. You may hear people refer to the doctrine of judicial precedent in English law. What this means is that previous decisions in court cases involving similar issues must be considered in future cases. The judge must then either apply the same law if the facts are the same, or distinguish the facts and make a new law. Under the common law system, an earlier decision of a superior court is binding on judges of inferior courts, and we'll come on in a moment to look at those courts. This produces a system which aims to be both certain and predictable. However, not every part of an earlier decision is binding on future cases. It is only the statement of law which decides the fact in a case which is binding. This you'll hear people refer to as the ratio of the case. Any other statements of law are obiter and not binding. So an example of this might be a case where there is a question about a breach of a maintenance obligation, but there's also an argument about the type of loss suffered as a result of that breach. If the judge in that case decides that there was no breach, then there would be no need for him or her to move on to consider the types of loss suffered. But if he or she still did look at the types of loss suffered, those arguments and comments would be obiter, as they are not what the judgment is actually about. Of course, no two cases are ever completely identical factually. Mine and Alex's jobs would be much easier if they were. If a case with very similar facts has been decided previously, it's relatively straightforward to apply the same law. It's also possible to apply existing legal principles to different situations in different areas of law by analogy. This is how the law develops and gives the system flexibility, while still providing a degree of dependability and certainty on which a party can generally rely. Whilst previous decisions cannot be disregarded at will, otherwise the doctrine of precedent would be undermined altogether, it is possible to distinguish a previous decision, where to follow it would lead to an inconvenient or unjust decision. This is done by a judge expressly stating that the present case differs on its particular facts or on the point of law involved. This again enables a level of flexibility within the system. A higher court may also overrule a decision made previously by an inferior court. A decision can also be overruled where the previous court did not apply the law correctly, where the legal principle is no longer desirable. Now, I'll mention EU law only very briefly, primarily because, in my view, the less said about Brexit, the better. From the 1st of January 2021, any EU law as it applied in England and Wales as at the 31st of December 2020 is now part of English and Welsh domestic legislation. Any future EU law will not be directly or indirectly applicable in England and Wales. The English court system has a hierarchy. It's important to understand this hierarchy, as decisions of higher courts are binding on lower courts and therefore more significant. For the avoidance of doubt, decisions of lower courts do not bind higher courts. So from the 1st of January 2021, the English court hierarchy is as set out on the slide. At the very bottom, we've got the county courts. Matters heard in the county courts generally have a financial value of less than £50,000. Their decisions are not binding and are very rarely reported. Next on the list, we have the High Court. The High Court is bound by the Court of Appeal and the Supreme Court, but not bound by other High Court decisions. They are, however, of strong persuasive authority. A High Court hearing is presided over by one judge. Next up, we have the Court of Appeal. The Court of Appeal is bound by decisions of the Supreme Court, even if it considers them to be wrong, and with limited exceptions is also bound by its own decisions. Court of Appeal matters are presided over by 3 judges. And at the very top, we have the Supreme Court, which was formerly called the House of Lords. This is the highest appeal court. Decisions made here bind all courts below it. The Supreme Court is generally bound by its own decisions, although it does have a right, which it uses very, very sparingly, to depart from its own previous decisions. Supreme Court matters are generally presided over by 5 Lord and Lady Justices, but for really important matters, like Brexit, 12 can sit. What this means in practice is that if you obtain a decision from a lower court that you're not happy with, you can seek to appeal that decision to the next court on the list. Now, as many of you will be aware, a large number of English shipping matters are first decided in arbitration proceedings, either before a sole arbitrator or a 3-person tribunal. If a party wishes to appeal an arbitration decision, then that appeal goes straight to the High Court and can then be appealed further from there to the Court of Appeal and the Supreme Court. Now, a right of appeal is not automatic, and in the majority of cases, permission will need to be obtained, in which the courts will consider whether there is an error of law or fact, or a point of general public importance which makes the matter appropriate for an appeal. Whilst a detailed discussion regarding arbitration is outside the scope of this talk, it's perhaps worthwhile noting that arbitrators are bound by High Court, Court of Appeal, and Supreme Court decisions. And whilst very few arbitration decisions are reported, those decisions are not binding on other arbitrators or on any of the courts, but they may have limited persuasive value. Now, I'll hand you back to Alex, who will explain how a time charter fits into the full contractual picture between a vessel owner and a cargo buyer and seller.
Thank you, Sarah. Thank you very much. It's perhaps worth also adding in relation to English law that when we go to law school, we learn about contract law, and a lot of contract law cases are shipping cases. Shipping people are good at fighting cases and taking them to court, and if a decision is made on a contract issue, then that applies to any contract issue in similar circumstances in any area of industry. So a lot of contract law is shipping law, which makes it very interesting. Okay, so what I think is quite useful is to, when we're talking about time charters, is to make sure we understand the context and we're clear about all the other contracts that might be in place when you are considering a time charter issue. And this is particularly in relation to cargo carrying vessels. So it doesn't apply so much to supply time, for example, or other non-cargo carrying charters, but I'm thinking of trade. So shipping exists, I would argue, because of international trade. We buy and sell things internationally, and we need ships to move the goods. So if we're looking at the context, I like to start with a seller. I have to say I normally do this on a flip chart. So it's the first time I've tried to do it on a PowerPoint, so we'll see how we go. So here is our seller, and the seller is going to sell goods to a buyer. And in this example, and this is just an example, of course, I am having another buyer, a sub-buyer. So there's another sale contract, and then a sub-buyer who I'm going to call the receiver. Now, in this particular example, I'm going to make the first sale FOB. FOB, for those who don't know, is an Incoterm. Incoterms are an abbreviation or a shortcut to various sale contract terms. So for the purposes of this, what I'm looking at is free on board. The buyer is just paying for the goods. The buyer is going to sell the goods to the receiver, CIF, another Incoterm, which means cost, insurance, freight. That means the receiver is paying not only for the goods, but also for the freight, i.e. the movement of those goods, and in this case, the insurance as well. Again, just an example. Now, what that means is that the buyer is looking to organize the ship. The buyer needs to organize the ship for this sale. So we need a ship. So here's our head owner who owns a ship. And in this, again, in this example, that head owner is actually going to time charter their ship to a charterer. And in this example, that charterer is going to also charter to a subcharterer. Now, for the sake of this example, I've put in a trip time charter here. And you might ask, what is a trip time charter? A trip time charter is a charter, instead of for a duration or for a period of time, it is for a period. So you're paying for time, but you're paying for the time that it takes to get from A to B. So it's a trip time charter. That subcharterer is now going to, in this example, voyage charter to the buyer. So the buyer is actually a subcharterer. And there we have our voyage charter. So whilst a time charter is a contract for services for a ship and crew, a voyage charter is a contract of carriage for the movement of goods from A to B. Now, there is another contract that is really important to understand in this context. I'm sure a number of you know what that is, and I'm going to put it in here now, which is the bill of lading. The bill of lading performs three functions. It is a receipt for the goods, so the goods go on board a ship and it is a receipt. The second function is a document of title. We'll look at that in a second. And the third is evidence of a contract of carriage. So there is another contract here. Who is that contract between? Well, it's given in this example, at least, to the seller, who is the shipper of the goods. And the other party to this contract is a party I'm going to call the carrier. But that is just the name of that party. The carrier will be either the head owner, the charterer, or the subcharterer. And you have to look at the bill of lading to work out who is the carrier in that contract of carriage. So what we might call a master's bill of lading, signed for and on behalf of the master, is likely to be a head owner's bill of lading, but the bill of lading could be signed by the charterer on its own account. Often in container trades, the charterer will be issuing its own bills of lading, and so the carrier will be the charterer. So I just want to make that point there. Now, so there's your evidence of a contract of carriage. Now, how does this document of title work? So in my example, the buyer is going to open a letter of credit to pay for the goods. So what effectively that's doing is saying to the bank, if the seller gives you the correct documents for the sale, then you can give them the money. And so the seller will, and the sort of documents will be things like the commercial invoice, the quality certificates for the goods, and the bill of lading. So those documents come across to the buyer, including the bill of lading. So the buyer now has the bill of lading. And then let's do the same thing with the receiver and the buyer. So here we have another letter of credit, and the bill of lading is now going to travel across to the receiver. And now what you have is, in theory at least, the receiver with the bill of lading in their hands. The ship arrives at the discharge port, and what they do is they can present the bill of lading to the carrier and say, please, can I have my goods? And indeed, if those goods are lost or damaged, there may well be a claim under the bill of lading. Now, when the purpose of looking at this diagram is to put the time charter in context. So when you are looking at a time charter, you need to have all of these other potential contracts in place. Now, of course, you might not have a trip time charter or a voyage charter. You might just have a voyage charter. But this is the sort of diagram you should have in your head when you're looking at many issues in time charters. And you need to bear in mind that in English law, we have what's called privity of contract, so an intention to create a contract between two people. And yet what you can see here with the Master's Bill of Lading is that in fact the head owner has entered into a contract of carriage with a seller. They may have absolutely no idea who that seller is, and even more extraordinarily in many ways, that document can pass and create a contract unique in English law, which pops up between the receiver and the carrier. So, you know, the idea of this slide, and no doubt we will come back to it on many occasions during this course, is intended to put that time charter into context. And with that little intro, I will perhaps hand over to Sarah again to go through the time charter in a bit more detail.
Thank you, Alex. So Alex has explained to you how a time charter fits into the bigger picture and the contracts that link the cargo with the vessel. We're now going to look at the key elements of a time charter in a little more detail. So a time charter can be described as a contract between a ship owner and charterers for hire of a particular ship and services of its crew for a period of time between safe ports carrying lawful merchandise. So we'll now look at those elements in a little more detail. As you'll hopefully appreciate, any one of these topics could be the subject of a whole webinar series. In this talk, we'll aim to give you an overview, and in the rest of this webinar series, we'll delve into each topic in more detail. So, as a contract between a ship owner and a charterer, one of the key issues that the parties will be concerned with is who pays for what. Generally speaking, the rules are: hire is paid for by the charterers. This is their basic obligation under a time charter. Fuel or bunkers are paid for by the charterers. Now, as the charterer needs to provide and pay for the fuel, they'll be reliant on the owners giving them information as to what is needed and the vessel consumption. Port charges are also paid for by the charterers, as is pilotage and port agency fees. As for other expenses, so that could be things like war risk premium, these are generally also paid for by the charterers, but the case law is limited as to what is covered by this sort of catch-all provision. Owners, on the other hand, pay the crew wages. Now, whilst voyage charters will be covered in a separate webinar series, it's worth noting that under a voyage charter, the charterer generally pays only freight and the owners are responsible for everything else. So we talk about a charter party being a legally binding contract. But in English law, that contract doesn't have to be signed or even be in writing. Whilst it would be uncommon and certainly not very sensible to rely on an oral contract, many charter parties only evidence by recaps or main terms. A recap, when we use the term recap, we're generally referring to a chain of emails in which the brokers, or sometimes the parties directly, negotiate the terms of the charter. Those emails will go back and forth, and the number of issues which have not been agreed will reduce. When everything has been agreed, the parties will state that they are fully fixed, or they'll say all subjects lifted, meaning that a deal has been done and a contract formed. In most cases, in the final email, the parties will summarize all of the terms that are agreed. And that is the recap. The recap will only generally include the most obvious terms, so the parties, the hire rate, duration, and anything sort of particular to that charter. But of course, the charter party requires far more detail than that, and often the recap will refer to a pro forma for those other terms. This pro forma could be a charter that has previously been agreed between the parties, or to a standard form contract, such as something like the NYPE, the ball time, supply time, shell time, and the various versions of those, which are normally referred to by the year that they were published. The recap will generally make clear that to the extent that there are any inconsistencies between the recap and the pro forma, the recap will prevail, and that's also the common law position. In practice, it's much better to ensure that you have the certainty of a fully agreed and signed wording, as many problems that we see begin with a dispute about what the parties have agreed. In some jurisdictions, unlike England, a contract must also be signed before it can be relied on legally. And therefore, in some situations where you have an unsigned contract, there can be issues with enforcement. Under English law, as I mentioned, that there is no contract until all the main terms have been agreed. Therefore, if a recap still contains subjects, generally there is no binding contract until those subjects have been lifted. And as you'll have seen from Alex's slide, the charter party is a contract between parties that we call a ship owner and a charterer. But the owner may not actually or beneficially own the vessel. The owner may in fact be a charterer under a long-term charter. They could be a bareboat charterer or even an agent. An owner who is not the registered owner of the vessel is normally called the disponent owner. Now, the parties to a contract to a charter should be clear, but that's not always the case, particularly where there is no recap. And when looking at issues like this, the starting point is, who has signed the contract? Did they sign it just giving their name, or did they say as agent for someone else? So, for example, Alex Davey as agent for Birketts. If they say as agent, it can then be necessary to check whether that is actually correct. It's normal to see brokers signing charters as agents for the party that they represent. There can then be disputes about whether an agent actually had permission or authority to enter the contract on behalf of the party that they allege they are acting for. So in the example I gave, Alex Davey as agent for Birketts, did Alex Davey have authority or permission to do that? Finally, and perhaps it's an obvious point, but any charter party should contain a law and jurisdiction clause. For example, English law, High Court London, or English law, arbitration London, LMAA terms. This is a crucial time charter clause as it sets out the law that must be used to interpret the contract and the forum to hear any disputes. Whilst it is the norm for the law and jurisdiction clause to match, so English law, High Court London, you do see split law and jurisdiction clauses. So English law, arbitration Hong Kong, which means that the charter will be interpreted according to English law, but any dispute will be subject to the Hong Kong arbitration procedure. So the terms of a time charter that we've been talking about can be split into conditions, warranties, and innominate terms. Now, breach of a condition allows an innocent party to terminate the contract and claim damages. So that's a most serious breach. Breach of a warranty only allows the innocent party to claim damages. Breach of an innominate term always gives rise to a right to claim damages, but it can also allow the innocent party to cancel if the breach is so serious so as to deprive the innocent party of substantially the whole benefit of the contract. Generally speaking, as I've said, conditions are those terms which are expressly identified as conditions, have been held to be conditions, and or are intended to be conditions. Generally, the vessel must be as described in the charter party. If it is not, and the breach term is a condition, the charterer may refuse to accept delivery. So examples could be if the name or class or flag or present position are incorrect. Substitute vessels are not allowed unless this is specifically agreed. Most charter parties will include an obligation on seaworthiness, at least at the time of delivery. Where the charter party incorporates the Hague Rules, which we'll discuss further in our webinar on cargo claims, then the obligation normally changes to one that the owner will exercise due diligence to make the ship seaworthy before and at the beginning of the voyage. Now, there's no clear authority as to when this obligation applies in a time charter context. The academic view is that it applies before each voyage under the charter party. If the vessel is not seaworthy at some other point during the charter party, that's not necessarily a breach of the charter, and we would need to look elsewhere for a breach. The maintenance obligation normally requires the parties to keep up a prudent programme of inspections and take reasonable steps or exercise due diligence within a reasonable time to do repairs, but that's not the same as the seaworthiness obligation. Speed and performance, that refers to the promises given by an owner in a charter that describe how fast a ship can go and on what bunker consumption. This is really important because the faster and more economical a ship is, the more attractive she will be to a charterer. Perhaps it's obvious, but because a quicker and more economical ship will allow them to do more business at less cost, because as you remember, they pay for the fuel. Speed and performance clauses are generally innominate terms, but this does depend on the particular clause. Speed and performance promises are normally given in good weather only, and the charter will then set out what constitutes good weather, and there can be a great deal of debate about that. Owners and charterers will often use weather routing companies to assist with route planning, but also to monitor and record the performance of the vessel. Sometimes you'll see speed and performance warranties given without guarantee. If that's the case, those promises are unenforceable, provided they are given in good faith. Now, in return for the services of the vessel, the charterers must pay hire. Payment is normally made in advance, except for the first payment. It's generally accepted that that first payment is not due until the vessel is delivered. Payment must be in cash or its equivalent, which doesn't mean that someone has to turn up with a bank bag of money. What it means is the owners must have free use of the money on the relevant day, usually just a bank transfer. And whilst it would depend on the terms of the charter, generally hire must be paid in full without deduction. If the charter is silent on what may or may not be deducted, the charterers may be entitled to keep back sums of money where they have been deprived of the use of the vessel. Now, most time charters include the concept of off-hire. An off-hire clause is a specifically agreed set of circumstances where hire is not due. So examples could be a breakdown of the vessel or damage to the hull. It's really important to understand that for off-hire, there is no need for a breach by owners. Off-hire will be the subject of a webinar later in this series. And the charterers will have the use of a vessel for an agreed period of time, which is typically fixed as a number of calendar months, potentially years, except for trip time charters. The charter provides for times and places of delivery to the charterers, and then redelivery at the end of the period to owners. So the charter party period, so we mean by that early and late redelivery claims, they'll also be the subject of a webinar in this series. Whilst the owner will remain responsible for the safe navigation of the vessel, he operates that vessel in accordance with the orders given by the charterers. The most important orders are where to sail and what cargo to load. Of course, that is what a vessel is supposed to do. A time charter is for a period of time, as I've just mentioned, and as such, neither the charterer nor the owner are likely to know in advance where the vessel will go during the charter. On day one of a 3-year charter, they won't know where the vessel is going to be going maybe 14, 15 months later. For that reason, apart from geographical constraints, the charterers will normally agree to order the vessel to safe ports. Even where this isn't an express term, it's probably an implied term in time charters. Safety includes both geographical and political safety. Now, safe ports is a big topic and will be covered in a webinar later in this series. Most charters also contain a list of cargoes excluded under the charter party and a specific exclusion for dangerous cargo. In any event, there is an implied obligation on the charterer not to load a dangerous cargo without notice unless the owner or master knew or ought to have known of the danger. This obligation is an absolute one, therefore sort of irrespective of whether the charterers knew or should have known of the danger. It's not up to a master to question unduly the orders of the charterers, but is also not obliged to follow orders which the charterers are not entitled to give, or any orders which endanger the safety of the ship and the cargo. The master is also not obliged to follow orders immediately. He can take time to consider them and make inquiries. The master is also not obliged to follow orders which trespass on his responsibility for navigation and seamanship, but he is obliged to follow, for example, routing advice, provided it does not endanger the ship or the crew. So as I just said, master isn't obliged to follow orders which trespass on his responsibility for navigation and seamanship, but in return for that, an indemnity will normally be implied against any liability incurred by owners as a consequence of following charterers' orders. unless it can be said that the risk is one which the owners have agreed to bear, or unless the act of the master in following those orders was manifestly wrong or tortuous. In order to rely on an implied indemnity, there must be an unbroken chain of causation between the order given by the charterer and the loss suffered. The majority of time charters, including the NYPE form, give charterers the express right to sublet. This means that the owners will not have a direct contractual relationship with the subcharterers, as explained on Alex's slide. Therefore, the subcharterers, they cannot sue the owners directly to enforce their subcharter. This is why claims are often passed up and down chains on the so-called back-to-back basis. The purpose of this talk was to set the scene, which I hope we have done, and explain the basic principles of English law and time charters. Those basic principles will be carried through this series. So I'm just looking over at the list of questions that are popping up. The first one I can see, someone's asked a question here. Can you explain a little more about the right of withdrawal and what that means? Alex, do you want to take this one?
Thanks, Sarah. Yes, happy to do that. Right, the right of withdrawal. So I think it's worth explaining this. That there is actually will be a webinar session on this. But if you think about, the first thing is hire. As Sarah said, hire has to be paid. It has to be paid on time and in full. If there's a breach of that term, the courts have recently confirmed that that is not a condition. There was a short period of time fairly recently when the court said it was a condition, and that would mean that any failure to pay full hire on time would allow the owner to terminate the charter, but it isn't a condition. So the reality is that if you look at the conduct, you need to look at the conduct of the charterer in why they have failed to pay hire and whether they're deliberately not doing so or not. But it doesn't automatically give you the right to terminate. Now, in many charters, that right to terminate is written in, so it's an express term of the contract, and they have the right of withdrawal. They're allowed to withdraw the ship. Now, that's hugely, it's a big step. It's a permanent step. It's not a temporary right of withdrawal. It's a permanent right of withdrawal if full hire is not paid on time. Now, some charters do include a right of suspension as well. That is temporary, but many just have the right of withdrawal. Now, because the right of withdrawal is so draconian, so serious, there is often what's called an anti-technicality clause written into the contract, which is a provision that prevents an owner withdrawing their ship without having given the charterer some warning, basically, and said, look, whatever the terms of the anti-technicality clause are, basically saying, if you don't pay the full hire within the next 4 days, or whatever the term says, we will then withdraw the ship. And the courts have required owners to follow the terms of their anti-technicality clauses very, very closely. And there is a case, as I say, the webinar will come on to, called the Lee High, where unfortunately for the owner, they did have a right to withdraw. Hire had not been paid in full, but unfortunately the owner got their notice wrong and therefore were wrong to withdraw their ship, and had to pay damages to the charterers. So it's very serious. The other thing that's worth saying in relation to, and this is why I wanted to come back to this slide, is that when a head owner is thinking about withdrawing their ship from a charterer, they need to recognize, we're missing the receiver bit here, but they need to remember they have a contract of carriage if they've got goods on board. So thank you, Sophie. So it's not just a question of terminating this contract if you have cargo on board. So as we will see when we come on to this topic, there is a practical question as to whether you can actually withdraw the ship if you haven't been paid hire, because you might have a cargo on board, and then you've got a problem because of your other contracts. So I hope that answers that question.
There's also a question here about, can you explain a bit further what you mean by back-to-back? And someone else has asked what happens if a party in the middle of the chain disappears. So I think probably what they mean by that is if a party goes bust or does literally disappear into the sunset. So let's look at back-to-back first. I think there can also be often be a slight misconception about what back-to-back charters means. And looking at Alex's slide, I don't know if I've got mouse control, but on my screen, I'm certainly waving around over the parties on here, which show head owner, charterer, sub-charterer. So those are two charter parties, as Alex is, I think, now showing you. If we just forget that the bottom one is a trip time charter for now, and for the purposes of this, just think of them both as time charters. So let's go with an example. If some machinery breaks down because it's not properly maintained, so the charterer on here, the sub-charterer at the bottom of the list, he won't be very happy because this piece of machinery, a crane, has broken down, and he'll want to pass the claim up the chain to his owner, so marked as the charterer on here, and say, the cranes are broken down, I'm not very happy, and I've suffered a loss. In theory, and probably in practice here, that charterer will simply pass the claim up again to the head owner. If those charters have very similar terms, as they probably would if they're time charters, that claim will probably flow through quite nicely from the sub-charterer to the charterer to the head owner, and the head owner can then either defend the claim if he says, no, I did properly maintain the crane, or he can say, yes, there was obviously a breach there and the claim will be paid. Now that's a nice straightforward example where the claim flows through, but often it doesn't work like that actually in the majority of cases. If we change the example and say the sub-charterer has a claim on the basis that the vessel was not seaworthy on delivery, and if we put some charter party dates on these, if the head charter is dated the 1st of January 2017, for example, and then the charter below is dated 1st of January 2020, so sort of 3 years between them. If there is an issue with the vessel being seaworthy on delivery in that sub-charter, that's an issue on the 1st of January 2020. It won't be straightforward for the charterer in the middle to pass that claim up the chain, because of course in his charter, that isn't the delivery date. The delivery date was 3 years previously. So he won't have a back-to-back claim. He would have to try and find another breach to be able to pass that claim up the chain, but it wouldn't be back-to-back. It wouldn't be a claim on the same basis. I hope that answers that question. And just very briefly, if a party disappears, if we look at those three parties again and say the charterer in the middle, it becomes insolvent or just disappears, there is no straight contractual claim by the sub-charterer against the head owner. There is no contract between them. So it would not be straightforward, and I hope this is answering the question here, for the sub-charterer to bring a claim directly against the head owner. It's not impossible to do so, but you would normally require some sort of assignment of rights to be able to do that. Without any assignment or something like that, there is no contractual link between the sub-charterer and the head owner allowing a claim to be made directly, so to skip out a middle party. I hope that deals with that. Alex, I don't know if you want to add anything on that before we move on to one of these other questions. There's quite a lot here now, so bear with me while I scroll through them.
Yes, thanks, Sarah. Yeah, I was just going to add to that because I think there's a questions come up on that whilst the actual contracts might not be back to back, there is also that credit risk as well, as Sarah said. So just so not only do you have to consider whether or not and analyze the situation to decide whether or not claims can be passed up and down the chain legally, but also you do need to consider your credit risk. It's no good having a claim against a sub-charterer from which you're passing down from the head owner if the sub-charterer is going to run off and not pay you, however good your claim is. So I hope that answers that question.
If I just deal very briefly with the bunker questions, the questions people have asked are, who is responsible for the quality of the bunkers? And then someone else has asked, if there's an issue with bunkers causing engine issues, should the lost time be counted as off hire? So taking those back a little bit, as we said, in a time charter, the charterers will be paying for and stemming supplying the bunkers. So just pausing there, if the charterer stems bad bunkers, so bunkers that damage the vessel or that don't burn properly, generally speaking, the owner will have a claim against the charterer, but you can get very complicated issues as to whether it was actually the bunkers that caused the problems. And most bunker clauses have quite specific requirements about the quality of the bunkers that have to be stemmed, and this sort of ISO standard of those bunkers. There will also be rules about mixing bunkers, so commingling old bunkers and new bunkers. And there'll also be quite specific testing requirements about what testing needs to be done of those bunkers when they are being stemmed. Now, if all of that is neat and tidy, and there is clear evidence that the bunkers stemmed were bad and caused damage, then there would be a claim by the owner against the charterer for any losses flowing from that breach in stemming the bad bunkers. But I should add, bunker claims, something that Alex and I have done and are currently doing rather a lot of. It seems the recent changes in bunker regulations has resulted in quite a few claims. They're often not straightforward, and the example I've given there is a very straightforward one, but it's very rarely the case. I hope I'm just going back to the questions to making sure I've answered them. The follow-up point was, should lost time be counted as off-hire? You would need to look at your particular off-hire clause in your contract and work out whether what has happened is an off-hire event, because as we've mentioned, for an off-hire event, there does not need to be a breach. You just got to look at the terms of the off-hire clause and see whether the facts fit within that. A bunkering issue is probably unlikely to be an off-hire event, but it really would depend on exactly what has happened and what the consequences have been to the vessel. Alex, I don't know if you want to say any more on that.
Yeah, off-hire, as I say, as you said, will come up in a webinar series because it is a topic in itself. The important point to remember about off-hire is you could find that technically speaking, a ship is off-hire because it can't perform the services required of it and time is lost. However, if that off-hire period has arisen because of something the charterers have done, i.e. perhaps stemming bad bunkers, then either, well, legally either the ship would not be, you just simply say it can't be off hire because it's caused by the charterers, so how can the charterers put the vessel off hire in those circumstances? Or you have a circular claim. So what happens is the owners say to the charterers, you're in breach, I have a claim for damages. What are my damages? My damages are the money you wouldn't pay me because you said we're off hire. So either way, you might well find there is a requirement to pay that hire.
Thank you, Alex. I think we'll just briefly touch on the two, let's say, almost identical questions about conditions, warranties, and innominate terms, and how can you tell? The short but unhelpful answer is it's difficult. The slightly longer answer is what it says in the charter is a good starting point. So if it says it is a condition, that is very often the case, although I say that with a very big caveat that I had a case about 10 years ago now, which was all about a clause which said it is a condition of this charter that, and it was that the crew had to have certain certificates. The crew did not have those certificates, and the charterer tried to refuse delivery of the vessel because the crew didn't have those certificates and terminate the charter. And the tribunal in that case said it's not a condition, it's an innominate term, and it's not that serious. So sorry, you weren't allowed to terminate. So whilst it can be a useful guide to look at what the Charter Party says, you've also got to look at the seriousness of the breach of that particular term and work out if it's so serious that it would deprive the Charter of entirely the whole benefit of the contract, then it's very likely to be a condition. But you also then would need to look at the case law, look for other examples of those clauses and see how they have been interpreted by the courts previously. I hope that is a slightly unhelpful answer, I appreciate. Much easier, I could tell you to see what it says. But I'd say it's not often the case. Alex, I don't know if you wanted to add anything to that.
No, you're absolutely right. You know, there are, if you think about it, there are, you know, take a breakdown, for example, a breakdown that is caused by some unseaworthiness of the vessel. It could be really very simple to sort out. It could take literally somebody half an hour, or you know, an hour or whatever. It could be very quick to do, and it would be extraordinary if in those circumstances there is a breach. It would be quite extraordinary if in those circumstances you could terminate the contract. So there's clearly not going to be a condition. However, the breakdown could be so bad as to put the vessel out of action for, you know, a very long period of time, which you might say is so serious as to deprive the innocent party of substantially the whole benefit of the contract. And in those circumstances, there might well be a right to terminate. So that's a classic example of an innominate term. It could be breached in different ways. So conditions, most of the time, you find many less terms that are conditions these days. I did spot another question. Actually, somebody asked about warranties. We're not. I should be clear. We're not talking about insurance warranties here. So that's quite a different thing altogether. We're talking about warranties as in terms that do not lead to the right to terminate the charter or a contract, not insurance warranties, which are a totally different beast.
The last question that just popped through is, do you see many rider clauses apply to time charters such as bull time and NYP 46 to alter them drastically? Again, this can be a whole topic in itself. Yes, we see all sorts of amendments to charters, to those pro forma wordings. Do those amendments change them drastically? Well, I guess it depends on how you define drastically and which particular clauses you're looking at. You do sometimes see pro forma charters where, you know, a very great deal is struck through, and actually they're primarily relying on the rider clauses. You know, you see sort of the off-hire provision completely struck through, and it would say see clause 36, and there'd be a whole new off-hire provision. Having said that, if someone has chosen to use the NYP form or the bull time form, one would hope it's because that's generally the form that they're looking for, and they want to tinker around with it as opposed to completely redrafting it. But yes, we do see quite drastic amendments to all of the standard pro forma wordings. I don't know, Alex, if you want to take that any further.
Yeah, just to say, also particularly in the tanker world and Shell time, BP time, you know, the pro forma will be normally quite a small part of what is a really quite a long contract in many cases. So whether not so much drastically changing the pro forma as just adding a lot of extra detail in there. So I hope that answers that question. Yeah, so really just a huge thank you to everybody. We've had a great response, and I hope you found it interesting and informative. Thank you to our marketing team who've helped us with this and made us rehearse it and run through it and make it all work. But thank you to them, and also to my colleague Tom Hodges, who I should have said at the beginning is the master planner behind all of this. So well done, Tom. I do hope we see you in the future webinars. Please do fill in the feedback. Please do ask some questions, and stay safe.
Brilliant. Thank you all.
Thank you.